Test. Can you all hear me?
Yep. Yeah, cool. All right. So this thing on top is you.
Got you. Is the Zoom started? Or are we video recording?
Wow.
It started? Okay. Good evening, everybody. The August 31st meeting of the Community Commission for Public Safety and Accountability is called to order at 6:36 p.m. We will begin with the call of the roll to establish quorum. Commissioner Brown. Present. Commissioner Driver is present. Commissioner Gomez. Commissioner Gomez is not present. Commissioner Loizan. Commissioner Nellis. Commissioner Nellis is not present. Commissioner Terry. Commissioner Terry is not yet present, but will be here shortly. And Commissioner Troncoso. Present. With 4 members of the Community Commission for Public Safety and Accountability present, we have a quorum and can conduct the commission's business. The next item of business is public comment. If you would like to share something related to the commission's work on public safety and accountability, you have a few options. You can speak at a public meeting. You can also submit public comment in writing by emailing your comment to Community Commission Public Comment at cityofchicago.org, or you can bring a copy of your comment to one of the commission's public meetings and give it to someone on the commission or someone on the commission staff. People who wanted to speak during the public comment period tonight were asked to submit their names in writing earlier tonight. Names were then drawn at random by a member of the commission staff. Speakers will be called in the order in which their names were drawn. If your name is called to offer public comment, we ask that you approach the microphone and line up in the order in which your name is called. If you cannot leave your seat to come to the microphone, please find a way to alert either a commissioner or staff, and we'll bring a microphone to you. When it's your turn to speak, please say your name and then spell your name for the record and then offer your comment. Each speaker will have 2 minutes. We have allotted a total of 20 minutes for public comment. Our first speaker for public comment is David Boykin. No David Boykin. Next speaker, Chloe Vital. No Chloe. David Olikoff. How do we get these if they're not here? Nobody knows? Okay, got you. Alex Perez. I think he's here. Followed by Lee Bilecki. I'm like, did they leave? Oh,
Well, okay, perfect. Thank you so much, commissioners, for hosting this meeting on the arbitration. I really do appreciate it. My name is Alexander Perez. I'm one of the district counselors for the 2nd District. It's a pleasure to be here. My comment, and this is my opinion, I'm very much concerned at the outcome of the arbitration and what's being proposed. As a district counselor, we exist for the state of transparency and accountability. And I think this flies in the face of the transparency and accountability. I've heard it said that, Chicago is a union town, and I respect that very much. My wife is a part of a union. But the issue for me is I think we're comparing apples and oranges. When we talk about the union, the FOP, we're talking about an organization that represents individuals that have the capacity to take life or alter life in extreme measures, extreme ways as well. So we're not talking about like a carpenters union where somebody took a car and drove off or something. We're talking about some very extraneous situations here. And so the ability to have officers skirt accountability and have this closed door arbitration, for me, undermines the progress that we've made in creating not only the CCPSA, but the police board as well. So I hope that my words are heard and that our city council members will vote down any measure that impedes transparency and accountability. And we hope to foster a environment of pro accountability and pro transparency going forward. My name is Alexander Perez. Thank you.
Thank you.
Good evening, everybody. Lee Bilecki, 22nd District Police Council.
It's my opinion the police deserve arbitration. The police board has shown in past cases that they have been swayed by public, political, and media opinion. The police deserve a fairer and more equitable system for discipline. In addition, COPA has been handing out excessive discipline for infractions not following the progressive disciplinary procedures. Police officers are human beings and mistakes happen. Discipline handed out has been more of a punitive nature rather than a corrective nature through training. No police officer will say they should not be held accountable for infractions. How can police officers have confidence in a system that is not fair? A fair response and not an excessive one is all they ask. Chicago is a labor city. Police officers are part of that workforce. For all they see and encounter, they deserve fair, not biased judgment. 600 police officers have given their lives for this city. I encourage city council members to accept the arbitration clause and give them a fair system. Arbitrator Ben has already ruled in 3 other municipalities where the arbitration standard has been accepted. And in this case, if it's rejected, it goes back to arbitrator Ben, who will reevaluate the city council's opinion and then resubmit it for another vote. If it gets struck down again, then it goes to the courts. It's already been established in 3 other municipalities that the arbitration system is accepted. And like I said, I can cite cases where the police board has not been fair on the side of the police officer and on the side of the city. Thank you.
Thank you.
Thank you for taking my comment. I apologize for missing my call. My name is David Orlikoff. I'm newly elected on the 14th District Council in the role of community engagement. I'm speaking about the arbitration decision and the ruling up for City Council. We just had this election and we had hundreds of thousands of votes cast by Chicagoans for district councilors to engage in this process, both through the monthly meetings as well as the councilors appointed to the commission, being part of this every step of the way. What the FOP is proposing to do and what this arbitration ruling would do necessarily would require the undoing of a host of laws that have been passed by millions of votes in this city. It is nothing less than an attack on our democracy, plain and simple. We simply cannot allow protected, group of special individuals to undo our democracy, to wage this war on the people of the city who have already made their voice clear. We had this election. We're not going to step away from what was just decided. The law of the land is in the people's voice, and that has been made clear. That is what we're going to abide by. Thank you.
Thank you. Yes.
You guys
Sure.
called my name, but I was
Okay.
a few minutes late. I apologize. Thank you. Hi, I'm Chloe Vitale. I'm one of the newly elected district councilors in the 12th Police District. And I wanted to also come speak out regarding the issue of bypassing the police board in favor of arbitration. I have some I have some public comment also that I've brought from Aurelio Garcia in the 19th district, one of my colleagues who couldn't be here because today is also their district council meeting this evening. Policing is notoriously the least democratic institution in our city and country. Police district councils were created to give the community more of a voice into Chicago's policing policy and practices. This decision completely undermines the purpose of our position. We must follow a process that prioritizes transparency and accountability above all else. That is the reason the police board exists, and we as district council members will fight to keep police transparency and accountability at the forefront of our service to our community. We unequivocally reject this ruling. So the only thing I would add to that is just that we are here as a result of decades long struggle for police accountability and community police oversight. This flavor of obstruction is not new, and we're going to continue to fight. Thank you.
We've reached the end of the public comment period. Thank you again to all our speakers. We value your input. The next order of business is approval of the minutes. Before today's meeting, draft minutes of the commission's closed meeting held on June 1st, June 14th, June 15th, July 13th, July 37th, and the regular meeting held on June 29th were shared with all commissioners. Are there any corrections to the draft minutes that have been circulated? If there are no corrections, is there a motion to approve the minutes of the commission's closed meetings held on June 1st, June 14th, June 15th, July 13th, July 27th, and the regular meeting held on June 29th?
So moved. Seconded.
It's been moved by Commissioner Brown and seconded by Commissioner Troncoso that the aforementioned dates and minutes be passed. Is there any debate on this motion? Hearing none, we'll now move to a vote. Those in favor of adopting the motion to approve the minutes of the commission's meetings held on the aforementioned dates, please signify by saying aye.
Aye.
Those opposed, please say nay. The ayes have it and the motion carries. The minutes are approved. According to the Open Meetings Act, the commission must review closed meeting minutes to determine whether the closed meeting minutes should remain confidential. The commission's first closed meeting occurred in February of this year. The commission conducted its first review of closed meeting minutes this month, 6 months after the first closed meeting. Upon review of the minutes, the commission has determined that the minutes from the closed meeting that occurred between February 17, 2023 and August 1st, 2023 should remain confidential, depending on the will of the commission. Our next order of business will be new business. We will begin by voting on modifications to the police board selection process that were previously passed on July 31st. Commissioner Brown.
As we described in our previous meeting, the commission has developed and passed policies concerning the selection of the COPA administrator, as well as procedures related to the selection of police board candidates. Since the meeting, commissioners and staff identified several modifications and clarifications to the procedures. The first thing was clarifying reappointment evaluations. The second thing is changing the process for background checks so that we don't have to arrange for criminal background checks on every eligible applicant. The third thing is clarifying how applicants are selected for interviews. The fourth thing is allowing commissioners to deny interviews to reappointment candidates. The fifth thing is explicit statement about commissioners recusing themselves based on conflicts of interest. And the sixth thing is changing the disqualification score from an average of less than 3 to an average of 2 or below. I move to adopt the changes to the police board member selection procedures.
Commissioner Brown has moved and Commissioner Troncoso has seconded a motion to adopt the changes to the police board member selection procedures. Is there any debate on the motion? If there's no debate on the motion, all those in favor, we'll move to a vote. All those in favor of adopting the proposed changes to the commission's police board member selection procedures, please signify by saying aye.
Aye.
All opposed, please say nay. The ayes have it, and the changes to the commission's police board member selection procedures are adopted. Our next order of business will be reports and updates. We will begin by providing a report from Commissioners Loizan and Brown regarding COPA and BIA investigations.
There we go. Based on public comment that we heard in some of our previous meetings, we wanted to provide an explanation regarding investigations of misconduct allegations of CPD officers that may have engaged in conduct that could potentially lead to criminal culpability. The collective bargaining agreement, or CBA, between the city and the Fraternal Order of Police establishes a process for officer discipline that the city is legally required to follow. Under the CBA, the city is contractually obligated to complete an investigation and give an officer chances to contest an allegation before an officer can be disciplined or fired. A stocker at a grocery store, an Amazon driver, or even me in my day job as an attorney are at-will employees. That means that my boss can fire me at any time. Police officers cannot be fired at any time because of the contractual agreement between the city and the police union. Even when very serious allegations of wrongdoing arise, that even rise to the level of criminal conduct, if those are raised against a police officer, CPD does not have the ability to fire the officer on the spot. Doing that would be a breach of the CBA. Instead, in those situations, no matter how serious the allegation, an investigation is conducted. When a CPD officer is accused of misconduct, two City of Chicago entities are primarily responsible for investigating. The Bureau of Internal Affairs, that is part of the Chicago Police Department, and COPA. BIA is a unit within CPD that investigates allegations of officer misconduct, particularly when those allegations could lead to criminal charges. COPA, the Civilian Office of Police Accountability, is an independent department within the City of Chicago that investigates allegations of officer misconduct that can lead to administrative or employment-related discipline. COPA's jurisdiction in cases are indicated by ordinance and are also outlined in Consent Decree paragraph 440. Generally, BIA and COPA have separate and distinct investigatory responsibilities. For instance, BIA investigates allegations of substance abuse and theft of property, while COPA investigates allegations of bias-based verbal abuse. We do have a handout that is outside on the table that designates specific types of conduct and who investigates it. So if you want to grab a handout on your way out, it gives you a list of what BIA generally investigates and then what COPA generally investigates, just for informational purposes. BIA and COPA do conduct simultaneous and cooperative investigations into specific offenses. For example, allegations of sexual misconduct. This is done routinely and is a matter of course. CPD does not get to decide that BIA will conduct an investigation into a specific allegation of activity on an ad hoc basis or in a particular case, simply because they think it may benefit a certain officer or the department. There are rules in place that govern when these cooperative investigations will occur. BIA and COPA work together on certain categories of allegations and have distinct responsibilities and purposes for investigating. BIA conducts the criminal investigation into the officer's conduct, while COPA conducts an administrative investigation. In other words, when BIA and COPA conduct simultaneous investigations, BIA's investigation can lead to criminal charges, and COPA's investigation leads to disciplinary charges. While conducting simultaneous investigations, BIA and COPA cooperate with each other, and all of the evidence that they gather is used by both entities. BIA and COPA have access to each other's investigatory files. So COPA can go in and look at those investigatory files whenever they want, and vice versa for BIA. BIA and COPA have different investigatory powers. For example, BIA has the ability to obtain warrants and issue subpoenas, criminal investigatory tools. COPA, on the other hand, while they can't obtain warrants or issue subpoenas, They have the authority to compel a suspect officer to make a statement about their conduct, an administrative investigatory tool that would not be used in a criminal case. The Office of the Inspector General also conducts independent audits of COPA and BIA officer misconduct investigations. That's all I got.
Thank you, Commissioner Loizen. Next, Commissioner, I will give an update on the CPD superintendent search process. I'm happy to report that Mayor Johnson selected Chief Larry Snelling to be the next superintendent on August 13th. Chief Snelling was one of 3 candidates nominated by the commission after a national search. By ordinance, the next step for the commission is to hold a public hearing with the person chosen to be superintendent. The community meeting to introduce Chief Snelling as the next superintendent of police is scheduled for Thursday, September 7th at 6:30 p.m. at the National Museum of Mexican Art located at 1852 West 18th Street. This is an opportunity for the community to get to know Chief Snelling, to make comments, and to ask questions. We hope you can all join us. People will also be able to post questions or make comments on the commission's website prior to the meeting. Sometime after the commission meeting with Chief Snelling, the City Council Committee on Police and Fire will have a hearing on a nomination, and the committee will take a vote. Then the entire City Council will get to vote on your nomination. After City Council confirms a candidate, the commission will hold another 4 public meetings with the new superintendent. Are there any questions? And for the record, Commissioner Terry is now present. We will now hear from Commissioners Loizan and Troncoso regarding the police board.
Can you hear me? Great. Over the past 2 weeks, we held interviews to fill several police board vacancies. We are happy to report that we received applications from and interviewed many qualified candidates. I believe it's upwards of 17 applications that we've received compared to 10 the first cycle. In the next few weeks, we'll be working to finalize our recommendations to send to the mayor, and we look forward to updating you at the September meeting.
Just to make a correction, is this working? Can you all hear me? That meeting is actually at 1852 West 19th Street. I believe I said 18th Street just now. Are there any questions for Commissioner Troncoso? Thank you, Commissioner. Commissioners Terry and Loizan will provide an update on several directives that they have been working on with the Chicago Police Department.
Hello, can you guys hear me? All right, thank you. So we've had several productive meetings with the Chicago Police Department on several directives. And so one in particular is the association's order. And the first update that we have deals with this current policy on associations, and that says that police officers are not allowed to be members or associate with members of criminal organizations. But the existing orders does not clearly define criminal organization or what it means to associate with a criminal organization. What CPD has proposed is a revised order with a clear definition of criminal organization. The commission has also proposed a number of changes to the CPD's draft policy. CPD has accepted most of the suggested changes, including our request to include monitoring of reporting on training and policy implementation. CPD will submit a draft of the association's policy by tomorrow, which is Friday, September 1st, for the commission to review. And once all commissioners review the draft policy, our commission will begin to solicit community input. So we do ask that you be on the lookout for that. We will notify the community once the community review process begins. We are hoping to vote on this order in our October 2023 meeting. And this has been an incredibly collaborative process, which we are happy to report with the Chicago Police Department. On January 2027, so this is a continuation of the CPD directive on directives. In response to CPD's attempts to pass the Criminal Enterprise Information System, which we all know as CIS or the gang database, as a CPD special order, the commission sent a proposed addition to CPD's directive on directives G01-03. The directive on directives governs the creation, review, and publication of CPD policies. CCPSA's addition to this general order included language codifying the commission's jurisdictional power and any policies that deal with the collection, use, maintenance, and purging of gang-related information. The commission and CPD last met in April to discuss this policy, and CPD did not object to the language that the commission had proposed in general order 1-03, but did object to the manner of the placement of that language in the order. So myself and Commissioner Loizon met with CPD last week to reanimate that conversation on this policy. And so CPD's leadership is reviewing the commission's draft policy again and will provide further feedback on this language and the next steps. So at this point, are there any questions related to this update from any of the commissioners? Go ahead.
To add one point, in our meeting with CPD about this particular general order, we had a very good discussion on how this general order is a priority for the commission and something that we are very concerned about. We have an expectation that we will be able to address this particular general order in more detail at our September 7th special meeting. Again, we had our first conversation with CPD about it in a while last week. However, they do understand that we feel that this is urgent. And so we fully expect that we will be able to discuss it on September 7th.
So what happens to the original thing where it was supposed to then be a special order? Would it come out of being a special order if you all agree in the end, or does what they wanted to have as a special order stay as a special order and this is going forward?
The language of this general order would preclude CPD from having a special order related to anything involving the gang database.
Are there any other questions?
The next item on the agenda is a presentation and discussion on the arbitration in the police, on the arbitration decision in the police disciplinary system. If you could give me a second, I actually prepare some remarks. And we will also hear from our Public Safety Inspector General, and I'm going to stand to deliver these. How about now?
Yeah.
I know arbitration is a new concept for a lot of folks. Please check out our one-page handout if you haven't already. There are copies up front. Right now, I'm going to give you a quick overview of why we're talking about this today and why I think arbitration for police misconduct cases is a mistake for Chicago. Arbitration is a process for resolving disputes outside of the courts. The current contract between the FOP and the city of Chicago empowers arbitrators to settle negotiations, break stalemates, and issue orders that the parties must follow. The contract also offers arbitration as an option for police officers who are accused of misconduct and face suspension of less than a year. But for more serious cases, where an officer faces suspensions for more than a year or full-on termination, those cases go to the police board, a 9-person public body that our commission now oversees. We are literally in the process of nominating police board members right now. But this could be on the verge of changing. The FOP has been calling for arbitration to be an option for these more serious cases. The city of Chicago has rightfully disagreed. Because they didn't reach an agreement, the issue went to an arbitrator named Edwin Benn. That's when this ruling took place. On June 26, 2023, citing state law, arbitrator Edwin Benn ruled that officers must have the option to take their case away from the police board and to be heard by arbitrators like him. Arbitrators who tend to dole out lighter punishments than the police board, who aren't public bodies like the police board, who aren't overseen by communities like the police board. That brings us to why we're here today. Edwin Benn's decision will not take effect unless the city council votes to approve it. As that decision nears, it's important for all of you to know what's at stake and to have your voice heard. We are about to hear from our city's Public Safety Inspector General, who I believe is very knowledgeable about this particular subject and most qualified to offer an objective and unbiased opinion. I want to be clear about the way that I feel about this particular subject. The commission that I am president of now has the word community as the first word in its name. That is who we are here to represent, and that is who will always be at the forefront of every decision we make. This is a commission that is birthed out of a 50-year struggle for police accountability, one that can trace its roots back to the assassination of Chairman Fred Hampton, who our mayor honored just yesterday, naming a day after him. I'm clear on why this commission exists and what its purpose is. I know that thousands of Chicagoans fought to make this a reality, and they rightfully have sky-high expectations of us. That is the lens through which I am viewing this issue. With that being said, I also want to state very plainly and very clearly that this is not an attack on the Chicago Police Department or an attack on Chicago police officers. In fact, it is my belief that enhanced oversight benefits everyone. The summer arbitration decision, if allowed to stand, and if subsequently approved by the city council, will set our city back decades. It will drive the process of accountability behind closed doors and put the most egregious of offenses in the hands of people who don't have any investment in the health and the safety and the protection of our communities. It strips away the public's right to offer public comment and press city officials about the decisions that they make. Independent arbitrators are not accountable to the public. They cannot be voted out of office. You have no right to hold city officials who appointed them accountable because you don't even know who they are. Arbitrators don't even have to live in the city of Chicago or give a damn about its residents because that's not a prerequisite of the job. Chicago is a city that labor built, and I support collective bargaining. I support the right to organize, and I support objectivity. But when your job comes with the power to take away someone's property, the power to take away someone's freedom, the power to take away someone's life, that bar must be higher. Just like doctors, lawyers, and politicians, that bar must be higher. And having a higher bar means having a more transparent approach to discipline. I will be the first to tell you that I have not been satisfied with the production of the Chicago Police Board. It's been far from perfect. In fact, at times it's been flat out bad. I trace that issue to the fact that for decades on end in Chicago, one person appointed every single person in the accountability infrastructure in this city, and that was the Chicago mayor. And many times that subjected both the public and police officers to the political headwinds of the day. And that ain't right. But that day is over. These members are now selected through a public process that is both open and transparent, and it is governed by the CCPSA. And we have no plans to go backwards. I am not a lawyer. I cannot argue the legality of this. But from where I stand, driving this process of police misconduct of the most serious cases behind closed doors in a city that has struggled as mightily as Chicago has is the absolute wrong way to go. And I plan on fighting that decision alongside the Johnson administration, alongside grassroots organizations, alongside any district council member who agrees with me, and anyone else on this commission, and any Chicagoan who believes this decision to be unjust. Education on this issue is critical. That is why we have invited Tabara Richardson here today. Tabara Richardson has served as Deputy Inspector General for Public Safety for the City of Chicago's Inspector General Office since October of 2022. In this role, she oversees independent, objective evaluations and reviews of Chicago's police and police accountability agencies to enhance public safety, protect civil liberties and civil rights, and improve the relationship between the police and the communities that they serve. Previously, Richardson served over a decade as a criminal prosecutor. Before joining the OIG, Richardson served as counsel to the Illinois Attorney General on social justice and equity. She also worked as an assistant United States attorney in the Northern District of Illinois and as an assistant state's attorney in Cook County. Richardson participated in Project Safe Neighborhoods and the James B. Moran Second Chance Reentry Court, where she worked to help convicted felons successfully reenter society and prevent participants from recidivating. And with that, I would like for you all to welcome her and thank you for being here today to talk to us.
Thank you all. Is it on? Okay. Thank you.
For raising the temperature a little bit.
Thank you all for having me. As you've just been told, my name is Tabara Richardson, and I serve as the Deputy Inspector General for Public Safety. I am a lawyer, but I am still not here to argue the legality of the decision. I'm simply here to give some facts. Going back to approximately 2 years ago, the Office of Inspector General, specifically the Public Safety Section, wrote a report regarding this issue that we are discussing here today. The report describes the disciplinary grievance procedures for non-exempt CPD members. So when I say non-exempt CPD members, I'm talking about officers, sergeants, lieutenants, and captains. And I'm going to give you a broad view of the disciplinary system. Commissioner Lois has already given you the background as it relates to when an allegation is made. Then either the Bureau of Internal Affairs or COPA, depending on whether COPA has jurisdiction, will look into that investigation. The Office of Inspector General also conducts investigations into some of the allegations against CPD members, but the majority are handled by either COPA or BIA. If the department goes on to issue discipline, so I'm also not going through the process that's in between when a allegation is sustained. There's command channel review. I'm not going through the details. For those details, we actually have on our website, igchicago.org, we have disciplinary charts. There are 20 of them. They vary depending on the member's rank and the recommended discipline. But fast forward into if discipline is sustained and the department goes on to issue discipline, after the review process, the CPD member facing discipline may accept the discipline or grieve the discipline, which simply means they may decide to dispute that discipline. Depending on the rank of the officer and the recommended discipline, officers may proceed to one of three options: the binding summary opinion process, which is conducted by arbitrators, arbitration, or proceed to the police board. And again, that varies depending on the officer's rank and the recommended discipline. Some other cases are settled, which we also cover in the report, but I will spend less time talking about for today's purposes. But I would recommend everyone going to the IG's website and looking at the grievance report, which I will say one of the individuals who helped us with that report is actually in the room, Robert Owens. Moving forward, so with this inquiry, we set out to determine the extent to which discipline issued to sworn CPD members changed as a result of the grievance process, and OIG also identified justifications offered by arbitrators for why they made their decisions to reduce, eliminate, or maintain discipline for the grievance. This review excluded consideration of the automatic reviews by the police board, where the recommended discipline was more than 365 days or separation. OIG reviewed the results of disciplinary grievances resolved over a 3-year process. And during that time frame, we looked at 370 disciplinary grievances which were resolved or settled. The 370 disciplinary grievances accounted for approximately 52% of all the cases eligible for grievance. And so you may ask why we didn't look at 100%, but I'll go back to the number 370. That was the number that was actually resolved during this time frame. And also because not all sustained disciplinary cases can be grieved, the 370 disciplinary cases account for 39% of all sustained disciplinary cases. Now I'm going to move into our findings based on looking at those numbers. We reached a number of findings. The first finding was that more than half of all eligible cases were grieved. Of those grieved, 78% resulted in discipline that was either reduced or eliminated. The reduction of issued discipline was the most frequent outcome for all grievance pathways except arbitration. The most frequent outcome of arbitrations was the complete elimination of discipline. Then we also looked at factors identified by arbitrators that weighed into their decisions by looking at the binding summary opinions decided by arbitrators. In those instances when discipline was reduced, the most common factors were cited as officer history mitigating and no deterrent effect of penalty, which reflect arbitrators' assessment of the issued discipline as unduly harsh and warranting reduction. In those instances where the discipline was eliminated, the cited factors were insufficient evidence of the investigation, and that was the most cited factor. The other commonly cited factors in cases where discipline was eliminated suggested arbitrators' belief that the issued discipline was unwarranted. And last, when arbitrators maintained the discipline, the factors cited were, the most common factors were that the basis for discipline, such as sufficient evidence, investigation, or admits guilt. And they also rejected arguments for reducing discipline, citing factors such as union grievance arguments unreasonable and seriousness of offense aggravating. That was our first finding. The second finding was that the disciplinary grievance procedure lacks transparency. When a sworn member grieves the issued discipline, there is typically no public information about any of the facts of the case. Arbitration awards are not published by the city as a matter of course. Moreover, the Illinois Freedom of Information Act, also known as FOIA, makes the final outcome of arbitrations in which discipline is imposed accessible to the public, but FOIA permits withholding all records where no discipline is imposed. So what that means is if the discipline is eliminated, then that's the end of it. You won't have access to those records. But in cases where discipline is imposed, records other than the final outcome of arbitrations could still be withheld in response to a FOIA request. Therefore, the facts not readily available to the public as a result of arbitrations include how the final discipline changed from the issued discipline and the arbitrator's rationale for any changes from the issued discipline. Accordingly, that would make it quite difficult to engage in an evaluation for fairness and consistency. And I dare to say that this is important not only for the public, but also for our CPD members who are subject to discipline, if I am one of the percentage of folks who have my discipline maintained compared to folks who get theirs reduced or eliminated, I'd like to be able to compare the rationale to make sure that I'm being treated fairly in the situation. So I think it's important for the public and CPD members to have a transparent disciplinary process. The police board is actually the exception to the lack of transparency because the police board publishes the outcomes and its rationale of the cases it hears. So you can go on the police board's website, you can look at their decisions, and you can also tune in to their monthly meetings. I'm not going to spend a lot of time on settlements, but currently neither CPD nor the Department of Law publicly reports on grievances that reached a settlement between the parties. As a result of those prior findings that I just talked about, the OIG recommended that CPD and DOL make information about disciplinary grievance procedure cases and the outcomes of binding summary opinions, arbitrations, and settlements publicly available in a manner that protects privacy. The third finding regarding the settlement process is that it lacks transparency and consistency. Again, the settlement process includes reductions in discipline and removal of rule violations from CPD members' records. Not going to spend a lot of time on settlements, but I will just note that during the time period that we looked at, 92% of the cases resolved by settlement resulted in reduced discipline. Out of those 79 cases, 2 resulted in the discipline being eliminated and 4 resulted in the discipline being maintained. Our last and fourth finding is that the disciplinary grievance outcomes are shaped by a very limited number of decision makers. The requirement that the union and the Department of Law on behalf of CPD mutually agree to an arbitrator may explain the higher reoccurrence of arbitrators selected to resolve binding summary opinions and arbitrations. During the time period we looked at, it ultimately led to 3 individuals who are neither members of the department nor of any investigating agency. They tend to have backgrounds in labor law. Those 3 individuals had the final say in an overwhelming majority of the cases. Specifically, 90% of completed grievance arbitrations between the 3-year period we looked at had been assigned to 3 independent arbitrators. And they operate with vast discretion, little public transparency, and negligible substantive post-decision review. And I'll just give an example. Recently, we sent, because the police board's decisions are publicly available in the Office of Inspector General, specifically the public safety section's oversight capacity, we are able to look at their opinions. And when we think that there are things that can be improved, in their process, we're able to, because we see their rationale, send them letters indicating such. Going back to arbitration process, judicial review of arbitrators' decisions is extremely limited. Therefore, the 3 individual arbitrators during the time period we looked at had a great deal of power concerning discipline served by CPD members. And their decisions are highly unlikely to be disturbed on subsequent review. As a result, the OIG recommended that the Department of Law and CPD work with the unions representing CPD's sworn members to expand the pool of eligible arbitrators and review whether having so few arbitrators responsible for a large majority of grievance resolutions is consistent with the fair disciplinary process. Moreover, we recommended that they should consider formal procedures for assessing and evaluating arbitrations, outcomes, and the arbitrators themselves. In conclusion, a transparent disciplinary process is foundational to the operation of the police accountability system. Here, during the time period we looked at, where 39% of all sustained disciplinary cases for unionized sworn members were resolved by a grievance or settlement. It's imperative that transparency of the disciplinary grievance procedure is paramount and overdue. And such transparency in the disciplinary process is an entitlement of CPD members and the broader public good. So there has to be a better public view into arbitrations, including its rationale and outcomes. And I just say that to say that regardless of the outcome, right, we're discussing a specific issue. If it turns out one way, I don't think that that will be a woo moment. And if it turns out another way, I don't think that that would be a celebratory moment. This report was published 2 years ago before this was in place. And so, as I have just said, a large percentage of the sustained disciplinary cases that are grieved are still going to be decided by arbitrators, and transparency is imperative. So we're talking about issues concerning transparency. We're talking about issues concerning who the decision makers are. And then when we look at the outcomes, those outcomes where discipline is reduced, that happens frequently with both arbitrators and the police board, because the police board information is readily available. It didn't take long to look at their recent decisions in the last, we looked at, well, really just pulled numbers from 2018 through August 17th of 2023. And the police board had decided a total of 108 cases. Out of those, 39 were upheld. That's approximately 36%. But 33 included numbers where discipline was reduced or eliminated. That's still about the same number, about 30%. And so the biggest difference there for this discussion is the issue of transparency, where we can go to the police board's website, we can look at its thought process, its rationale, and that does allow us to compare the results and the rationale, the factors they're considering, to say whether it is consistent and fair compared to a system that right now is happening, as we'd say, in windowless rooms. And so the job at hand is to then shine a light in the room and make the information available to the public and to CPD members. That's all I have for you. I don't know if you all had any questions, comments, concerns, or am I free to?
Yeah, I think some commissioners, well, first of all, thank you. Thank you for taking the time. Is my mic on? Thank you for taking the time to speak with us and present. If you don't mind, I'd like to ask if there are any questions from anyone on the commission. Are you good with that? Any questions from anybody? Commissioner Terry.
Thank you so much for your presentation. So one of the questions that I do have is related to the fact that we know that portions of the union contract are still under negotiation. So how does this impact those negotiations, possibly if something like this was implemented? As we know, in other union contracts across the nations, there are limits around or implementation of like binding arbitration, where certain things can be arbitrated and certain things cannot be sent to arbitration.
Yeah, so unfortunately, I don't have an answer for you.
Okay, thank you.
But just to clarify, in the negotiations, eventually city council has to vote to agree to or not agree to the FOP contract. And so one place where this could go differently is related to city council and how city council votes. Is that correct?
That sounds accurate.
Commissioner Loizen.
Hi, I have two questions. The first question is, I just want to make sure that we have a level set on expectations here. So I want to make sure I'm understanding this correctly. Recognizing that at the moment, this is a contractual issue that is going to go to the city council, and the city council could say, we're not going for that in this contract. They have the authority to do that. My understanding is that's one opportunity for the arbitration decision to not necessarily be put in effect because it would be not approved by the city council. That's kind of one option, right?
Yes, that's my understanding as well.
The point of clarification that I'd like to make, and I think my concern is that the arbitrator's decision rests on an interpretation of an Illinois state statute, which he construes as state law that is binding on all unions, right? So in the event that the city council were to determine that they were not going to approve this portion of the contract, at that juncture, would the FOP have an opportunity then to appeal the judgment based on the legal issue through the court system?
That is my understanding.
Okay, so I'm saying that just to make it clear. I think it's important that everyone in the room understands that while certainly based on President Driver's comments and a lot of the public comment that we heard here, there's certainly a strong desire to send a strong message to the city council that transparency is paramount and that this decision should not be, what's the word I'm looking for? It shouldn't be supported by them, and that the contract shouldn't be supported by them. But I think it's important that we all understand that hypothetically, if that battle were fought and won, there's still an opportunity for appeal through the court system to try to uphold the legality of the arbitrator's decision based on the fact that he rested his analysis on an Illinois state statute, which the FOP could certainly argue applies throughout the entire state of Illinois, regardless of what the city council has to say about it. Is that a fair explanation?
So I will say that I'm not here in my legal capacity.
Understood.
In that way. So I'll say that interpretation sounds reasonable, but I don't have a legal opinion
Okay.
as to that. But what I will emphasize again is that I understand, right? We're talking about where the recommended discipline is over a year or separation, right? And so what we would therefore infer are the most serious disciplinary allegations. And so I understand how we are at this place, but I still want to emphasize that a large percentage of disciplinary grievances are still going to be, regardless of this outcome, they're still going to be decided by arbitrators. And so as we have previously recommended, and we can do, we do follow-up reports, but this is still an issue. And that's a part of my point. This is still an issue that is going to have to be addressed, our disciplinary grievance system, and making sure that how these decisions are made are publicly available, not only, right, because the government deserves to be responsive to the government, but also because CPD members deserve to know that they are being treated in a fair and consistent manner as well. And when arbitrations are private and folks are required to reveal their rationale or anything outside of the outcome, and those are only in cases where discipline is not eliminated, the information is not readily available for the public or CPD members who are subject to this disciplinary system. So this is the task at hand, but the task doesn't go away regardless of the decision, the outcome here.
So can I ask my second question?
Yes. Oh,
So my second question is, when you guys did your analysis, did you have the ability at all, and I understand the data is not readily available, but for arbitration, but did you have the ability at all to make assessments on other variables in the decisions, such as, like, for example, how old the investigation was, or if there were issues with the quality of the investigation, or any other, witnesses didn't show up, things along those lines? Were you guys able to account for any of those variables when you made this assessment?
Okay, so I don't have them down to the granular details, but when we looked at the factors relating to whether arbitrators eliminated, reduced, or maintained discipline, we gave the factors that were the greatest factors. So when discipline was reduced, those factors were looking at the officer's disciplinary history, that it wouldn't be mitigating, or that the penalty wouldn't have a deterrent effect. When the discipline was eliminated, those factors that arbitrators considered was insufficient evidence of the investigation. That was the most frequently cited factor. They also cited factors where the arbitrators had a belief that the issued discipline was unwarranted. And then when they maintained the discipline, typically the factors cited too were sufficient evidence of the investigation, or where the CPD member admitted guilt, or that the union or grievance arguments were unreasonable, and also looking at the seriousness of the offense. I will also point out that, I believe it's figure 6 in the report, where you can look at the numbers and compare the numbers for arbitrations, the binding summary opinions, police board decisions. That is also there as well.
As others have said, thank you so much for being here. We really appreciate your presentation. One question I have is, you mentioned in your report that the most common outcome in arbitration is completely eliminated discipline, and that in other appeals paths, the most common outcome is just reduced discipline as opposed to completely eliminated. Did the IG's office have any ideas as to why this pattern might be the case for this one appeals path?
I don't recall us citing to the specific reasons outside of the factors that we gave, that I just reviewed, where discipline was eliminated.
Okay, thank you. And then also, you mentioned that in cases of no discipline, that no other information is released. Why is that the case, or where does that rule come from? I would be curious to hear that.
Okay, so pursuant to the Illinois Freedom of Information Act, where no discipline is imposed, there is no requirement to then provide the information or those documents. And when discipline is imposed, then the requirement is to provide the outcome of the discipline, but not necessarily the documents that would tell you the rationale or the reasons for the discipline.
Okay, so it's in the Freedom of Information Act,
Correct.
essentially. Okay, gotcha. And then my last question is, does the city ever, or how often does the city refuse arbitrators that the FOP might select, and what's the frequency of that, if you have that data?
I don't have the data, but the agreed upon numbers they decide from a group of 5.
Gotcha. Thank you.
I just had one question, and it was just I think the number you said was 78% of the time a case goes to arbitration, it results in lighter punishment or discipline.
So that wasn't just for arbitrations, that was of all the eligible cases that are agreed.
All right. That was my only question. Thank you.
So that includes the police board as well.
Yeah, they promise you.
I know you can't give a legal opinion on this, and so maybe it's a question for the atmosphere, but if you want to answer it, I would love for you to answer it. Doesn't it seem like there's an inherent conflict of interest when an arbitrator that gives lesser discipline gets rehired to do the same thing over and over again? Doesn't it seem like a conflict of interest if their job depends on how they decide these cases?
Yeah, I don't have an answer.
Any other questions from any commissioners? I think a few of us have statements, but I think we can thank Ms. Richardson and we can make our statements.
Okay.
Thank you so
So
much.
just going back though, where you asked about the question, where it was eliminated, the citation was to insufficient evidence of the investigation and a belief that the discipline was unwarranted. But remember, we looked at this information even before we got to this point. A large majority of cases are still resolved through arbitration. So these issues still have to be addressed. All right, thank you.
Thank you. Thank you so much. I guess I should take a poll of commissioners who want to make statements before we close this part out. Isaac, Yvette, Beth, Ramel, did you want to say anything? Okay, so we'll go down the line. Yep.
So this is just what I wanted to say. I'm not going to be as impassioned as Anthony because I'm old and I don't get that worked up anymore, but I agree with almost everything that President Driver said about the need for transparency. Professionally, I live in a world where we use arbitration all the time and it works, but the stats are demonstrating that it doesn't work here. And given that information and given, I think what's clear that community members feel like they need to be able to see what is going on inside the process. I don't see how as a commission we could do anything but be very vocal about our belief that the arbitrator's decision is not the right path. But there is one point that Commissioner Driver made that I do really want to emphasize, and it's this. He said that he wanted to make it clear that this wasn't an attack on the Chicago Police Department. And what I want to emphasize is this. A lot of the district council members referred to the CCPSA ordinance and how that is a law that was passed in response to a lot of the issues we've seen with police over the years. In the CCPSA ordinance, it does require us as a commission to provide oversight over COPA and the police board. And so the fine point that I would like to put on President Driver's comments is this. This isn't an attack on the Chicago Police Department. It is an opportunity for us to reaffirm that we understand our responsibility, not only to community, but to the police, to ensure that COPA and the police board are fair, that we are choosing people to serve as police board members who are competent and qualified and unbiased. That in our oversight of COPA, we are ensuring that their investigations are not only timely, but appropriately done and thoroughly done. And we need to, as a commission, I would say, in light of this arbitrator's decision, I think that this is a really good opportunity for us to reflect on our responsibilities and to ensure that our oversight over the entities that are responsible for not only disciplining police officers, but ensuring that that discipline is fair, are being properly overseen by us. And so, again, to emphasize President Driver's point, I think that, you know, if anyone from the police department or the FOP is listening to this, I want you to to understand that in speaking for myself, and I think I'm echoing his point, we do recognize that in taking a stand against the arbitration decision, we also have a very serious responsibility to ensure that the police disciplinary process is fair across the board for both community and police officers.
In addition. No worries. In addition to what people have mentioned about how arbitrations are closed door, private meetings inherently with little transparency and other concerns, speaking personally, I also have concerns about the specific financial incentives involved in this latest ruling. Let me start by stating that I am not a lawyer or a mind reader. I do not know Edwin Benn personally, and I do not know what his intentions were with this decision. This is just my opinion. However, Edwin Benn not only is the arbitrator over the city's contract negotiations with the police union, which is how he made this decision, but also he himself has arbitrated disciplinary cases with officers in the past, according to Chicago Sun-Times reporting. Thus, it seems he's made a decision that could potentially result in a higher volume of cases, not only going to his niche industry, but also potentially his own business. This sounds like if you put a city vendor in charge of deciding if the city should use their own services more broadly. From Edwin Benn's resume posted publicly on the National Mediation Board, the government agency charged with coordinating labor management relations in certain industries, Edwin charges $1,700 per day for hearings, which would come out to roughly $600,000 a year if it was an annual salary working all year minus 2 weeks of vacation. I understand that arbitrator Benn is basing his analysis on an interpretation of an Illinois state statute, but still, on its face, the alignment of these incentives to me sounds like a massive ethical issue. Again, this is simply my opinion. This decision seems like the wrong move for our city and the wrong choice for public, transparent accountability. It comes from a place of understandable frustration about fairness from officers and others with the police board. But it seems as though it comes before our commission has had a chance to channel the community's frustrations into oversight and accountability over the police board, the whole community, civilians, and officers as well. The Empowering Communities for Public Safety ordinance that created this commission seems to be an antidote to several of the city's frustrations about the police board, and this decision does not even give this new transparent process a chance. I would urge our city officials to give us that chance. Thank you.
So first, I'd like to say that I do agree with Commissioner Loizon, and I do want to emphasize that that this is not an attack on the Chicago Police Department or its officers. That's not what my rationale or my thinking is based on. This is based on what I think is fair. This is based on my lived experience. This is based on my desire for the CCPSA not to become another city agency that just goes along to get along. It's based on understanding what it took to pass this ordinance and where we're trying to go. I sincerely do believe that a more fair police board for the most egregious offenses, that is a community-driven process where people have an open and transparent way of getting on the police board that is accountable to the city of Chicago, that lives in the city of Chicago, that votes and pays taxes in the city of Chicago, is a better system than someone who doesn't have to have any of those requirements. And I feel like it's just really important for me to make this last point. A lot of times I feel a lot of tension within myself because I have a lived experience that is very unique, but it's also very common in the city of Chicago. But I also have an obligation to the city of Chicago as a publicly appointed official, also and to my fellow commissioners. And I grapple with that tension a lot. But in this particular moment for me, with everyone that I've been speaking to, you hear a lot about him basing his decision on state law. And I don't want us to get confused and think that because something is law, that makes it ethical or right. That is not what I believe. And so I'm making a moral argument here. I'm not making a legal argument here. I'm making an argument based on the history of the city of Chicago and Cook County and what we've been through as a people, as a city, and as a community. And many times I feel like the law is like wielded like an axe on communities because that's supposed to be the end all be all. But I was sitting in the room when the last mayor told me that she'd never yield power and give up the right to appoint her own superintendent. And yet here we are. I was in the room when we were trying to pass the $15 minimum wage, and we wanted to get rid of the sub minimum wage. And that was struck down. And now there's a new mayor, and that's one of his main priorities. Those things were all law. State law is one thing, the Constitution is one thing, but that does not make it necessarily right. So if we lose this fight, which I don't want us to, I don't expect us to, I definitely want everybody in this room and everybody listening to not give up, because that just means we need to change the law. With that, if there are no further questions, we will move on to miscellaneous business. To connect with the commission via social media, you can find us at Facebook at /Chicago CCPSA, or search Community Commission for Public Safety and Accountability on Instagram and Twitter, CCPSA_Chicago, and YouTube at Chicago CCPSA. The commission's next regular meeting will be Thursday, September 28th, 2023 at 6:30 p.m. And I also want to make a correction. I think we got it wrong earlier about the meeting with incoming Superintendent Snelling. That meeting will be Thursday, September 7th, 2023 at 6 p.m. at the National Museum of Mexican Art, 1852 West 19th Street. Again, that is Thursday, September 7th, 2023, 6 p.m. the National Museum of Mexican Art, 1852 West 19th Street. And I hope to see you all there. And with there being no further business before the commission, this meeting is now adjourned.